What are the stages in trademark opposition proceedings? Stage 1. Filing of opposition and counterstatement. The initial step in opposing a trademark involves submitting a notice of opposition within four months of the trademark's advertisement or re-advertisement in the Indian Trademarks Journal. This notice, in the prescribed form TMO, can be filed online or in physical form, accompanied by the appropriate fee. It should outline the grounds for opposition and include relevant supporting information. After a formality check by the Trademarks Registry in India, the notice is served to the applicant off the opposed trademark. Within 2 months of receiving this notice, the applicant must respond with a counterstatement that presents the grounds supporting their application. It should also address the claims raised in the notice of opposition. No extension is permitted for filing the counterstatement. The trademark is considered abandoned if it is not used within the allotted 2-month term. Rule 4.2 facilitates an accelerated procedure by permitting the submission of a counterstatement before the formal notice of opposition's serving. Stage 2. Submission of evidence in support of opposition. The next stage is the stage where the opponent has the option to provide evidence supporting the claims made in the notice of opposition within 2 months, extendable by 1 month, after receiving the counterstatement. This can be in the form of an affidavit in order to strengthen their case and substantiate their arguments. The opponent may choose to waive this opportunity, relying solely on the facts stated in the notice of opposition. If choosing to waive, the opponent must inform the Trademarks Registry in India and the applicant within the specified time, or the opposition proceedings will be considered abandoned. Stage 3. Submission of evidence in support of counterstatement. The applicant has 2 months from the date they receive the opponent's proof or waiver in order to provide evidence in support of their application and the assertions stated in the counterstatement. As an alternative, the applicant may submit a letter supporting the allegations in the counterstatement, therefore waiving the opportunity to submit supporting documentation. Stage 4. Submission of reply evidence. The opponent has 1 month from the time they receive the applicant's evidence or waiver to provide more evidence if they so choose. This evidence supports the claims made in the notice of opposition that counters the applicant's counterstatement and evidence. Rule 47 provides a maximum time limit of 2 months for filing additional evidence, with extensions allowed on a case-by-case basis. Stage by hearing. As per Section 21(5) of the Act, the registrar must grant a hearing opportunity to the parties. Typically, within 3 months of evidence completion, an opposition hearing is scheduled. The parties receive notification, and a hearing date is set. The registrar decides whether or not the opposed trademark should proceed to registration. If so, with what restrictions or conditions after hearing from both parties and examining the evidence.